Good morning. This is Judge Alyssa Perez resuming the criminal docket for the 210th District Court for February 15, 2022. Again, all matters being heard are being heard in accordance with all emergency orders and directives regarding the COVID-19 protocol, and we are streaming all matters live via YouTube for public viewing. Oh, I'm Mr. Pantoja, so I'm going to call the next case. Calling cause number 2018-0D01606, State of Texas versus Susana Victorino. You have announcements, please.
Omar Carmona on behalf of Ms. Victorino, ready?
And Ms. Victorino is appearing from the downtown jail. We are scheduled for a bond hearing. I believe we had a probation status maybe last Thursday, and we were going to try and discuss things more fully today. Mr. Carmona, you may proceed on your bond hearing.
Your Honor, my client is born and raised in El Paso County, Texas. She is 44 years old. She is currently in a common law marriage with Mr. Arturo Maldonado. Mr. Maldonado, they have no kids together, but she is raising a child that is under 18. The other two are adult children, but she does help with financial support. She was cleaning houses in the past, and she is able to work, Your Honor. My client's common law husband, Mr. Maldonado, works at McDonald's, and he has indicated that he could help her get employment there. Let me go back. Your Honor, we understand the court's concern. I think we discussed this last time. Obviously, there was clear non-compliance with your terms and conditions, Your Honor. But given the amount of time, what my client has indicated is that, she knew what she was supposed to do. And then it was just an excuse after the other. She thought after 1 month, I didn't do anything. So, it was easy for the second month and third month. She didn't pick up any other arrests aside from the failure to ID when the officers were obviously going to execute their warrant on the probation violation, Your Honor. She would be living at 2005 Atlanta. That's a 79902 zip code, Your Honor. Obviously, Your Honor, this is difficult for my client. It's time away from her family, but yes, we understand this was brought on by her decisions, but we were asking the court to, asking for a fresh start, Your Honor, and if to report back on probation, Your Honor, with strict conditions of reporting, and we believe that she would be compliant after this, Your Honor. This is a very hard lesson for her learned.
Ms. King?
Your Honor, the state respectfully opposes the bond. So we have the DWI third or more was actually probated on October 9th, 2018. And the defendant stopped or absconded, as a matter of fact, starting on April 2019 all the way to December 2021. And to kind of just give you a summary of the facts of the current charge, the fail to ID out of County Criminal Court number 3, the officers were actually dispatched and she kept on giving a different name, and the officers eventually found some labels with her true name. So we still have this trying to abscond, trying to not show up. Other than her history, criminal history.
What has so she has some criminal history. How has she ever been successful when she's received probation? So has she ever completed probation successfully?
Your Honor, the probation was amended for a AFV back in 2013. And I believe the reason it was amended actually the state did file a motion to revoke on that case as well. So she does have a history of non-compliance in her probation. As of this case, the state did file an amended MTR this morning as well.
Mm-hmm. So I'm just scrolling through what I can see here in Odyssey. And for example, the most recent case, I guess, that predates our DWI third. Well, first of all, the bond is 500, right? Yeah.
That is correct.
Okay. So right off the bat, Mr. Carmona, on the bond, that request is denied. the bond is very reasonable. In fact, too reasonable, too nice. But in terms of the bigger picture, you know, Miss Victorino, I can't see anything here where you have taken probation seriously. So let me ask you, Ms. King, so there was a probation violation on an AFV back in 2016. And it says here, and maybe Carla can chime in on this. Oh, she is no bond. I thought it was a $500 bond. Thank you, Marissa. Sorry about
Your
that.
Honor, I believe misdemeanor failed to ID is the 500 surety or cash.
Right.
Okay, that's what I'm seeing in Odyssey. My apologies. So hold on the bond, Mr. Carmona. Let me look back then at on that 2016 AFV. It says released to WSAT. Is that the court that's out of the specialty court that's out of the 120th? And is that, what is WSAT? What are we talking about?
It could be, Your Honor. Could it be women's RSAT?
That's what I'm thinking.
I think that's what it was before, Judge. The
Okay.
women's
Right.
RSAT.
So Carla, can you see because it was for an AFV, a third degree felony, and then a DWI with a child, and then a DWI second, but that was time served. It looks like the only two that. Mhm.
If I may, Your Honor, I'm seeing here that in May of 2017, there
Uh-huh.
was an amended sentence that Judge Salas Mendoza signed, and there was an extension which began on June 24th, 2017, around that same time. And then I guess she was held on probation. And then I see here an order dismissing a motion to revoke filed 1/24/18, and her probation expired sometime early 2018, March 14, 2018.
Carla, is that, go ahead, Marissa.
The probation expired, the motion to adjudicate that was opened in 2018, no capias issued on that because she had posted bond on the bench warrant. And once you post bond on the bench warrant, we can't issue a capias. So because no capias issued on that MTAG, it didn't really stop the clock, I think. And so I do see like this kind of gap there. But the order to dismiss the motion to revoke was because the probation was expired.
Okay, so she just basically, her probation kind of just, expired or evaporated. So there were issues she didn't complete successfully. Let me go back.
Judge, if I may, so I'm sorry, I'm trying to open documents, but it takes a while. She had been previously on probation for the assaults that we were mentioning. And I know like on I just don't see the MPR filed on any of these, but the disposition says revoked to county jail, although she was modified to like the WRSAT that she had done and completed. I'm just trying to make sure if it was an actual, like if she was discharged or if it was actually maybe a revoked to county, like a reduced charge. I'm just trying to find, but these are old cases from.
Right, and then we have that DWI second, she was on probation for that, she got revoked, time served.
That one she did.
DWI with a child, that's one of those, another bench warrant. AFV in 2013. Failure to ID, again, we have a failure to ID this time. So my concern, Mr. Carmona, is that she has, over the course of, there's a bit of history here. Probation violation in 2007, failure to ID in 2007. So a lot of reasons, resisting arrest in 2006, no insurance, driving without insurance, assault of a public servant, another assault, family violence, failures to appear everywhere, a bunch of traffic stuff.
Your Honor, if I may. On the 2013 assault case, actually, I pulled up the old VN that was submitted to us. So she was actually modified in 2015, modified again July 2016, modified for the third time, May 2017.
Yeah, she's not good on probation. So, and she clearly didn't care. I mean, it's not like she isn't exposed to what her responsibilities are. If she ever decided, you know, to change her ways, I don't have a real big hope that she's going to do that here. So my apologies, Mr. Carmona, the request to reduce the bond, it's straight, right? So it's going to be denied. We need to figure out a number on Ms. Victorino and just go from there.
Yes, Your Honor.
Thank you very much. Thank you, Ms. Victorino. Who's next? Oh, I'm bailiff. Sorry. Do we have downtown? I think I heard when you're Ms. Victorino's the only one. So thank you very much.
Thank you. Bye-bye.
Okay. Thanks, Mr. Carmona. Okay. Let me do bailiff. Hold on a second. So Omar, are you handling Angel Harris? Okay,
Yes, Your
so
Honor.
if we can get to the annex, we'll do that one first. And because I'm just going to take count of who I see, we'll do Mr. Valles next. And then let me see who this John Joseph has. And then we'll do Carlos Robles. Is this Mr. Harris?
Yes, ma'am.
Okay, perfect. Let me go ahead. Oh, there was an add-on. Let me look this one up. Okay, let me go ahead and call the cases. Calling cause number 2021-0D03226, State of Texas versus Angel Harris. Also, the 2022-0D00133, also State of Texas versus Angel Harris, set for bond hearings. Mr. Carmona, you may proceed.
Thank you, Your Honor. Your Honor, I believe that the bonds are set at $55,000 and $2,000. My client was born and raised in El Paso, Texas. He is 21 years old. He is married with 2 children. He is a 2-year-old and a 4-month-old. My client is still working at National Pecan Factory. He would still have that job. He does have a high school degree. He lives at the 11210 Quetzal Drive. That's in Clint, Texas. That's a 79836 zip code. He lives there with his wife and kids. Your Honor, he will abide by any and all conditions that the court imposes, and he just needs to be out on bond to provide for his wife and children. And again, Your Honor, we are asking the court to consider a reduced bond, Your Honor.
And he has no resources, Mr. Carmona?
No, Your Honor. He gets paid very little at National Pecan Factory, and his wife does not work.
Okay. Ms. King?
Yes, Your Honor. The state is not opposing to the bond reduction. So there is only one. The only things I see in the criminal history was the credit card abuse, but that was in 2018. That was dismissed not guilty. And there was a successful pretrial diversion completed back for an assault causes bodily injury. And the offense date was, I believe, to February 16, 2012.
Okay. And on the, so the state is not opposed to a straight PR bond?
No, Your Honor.
Okay. Only thing, Marissa, can you clear up for me? I'm seeing the 55,000 on 3226, but that other case number, is there a bond? I think Omar said it was a $2,000 bond, 2,500 corporate surety bond posted. Oh, so he already posted on the other
He
case?
already posted it. It is, he's only booked on the 3226 case.
Okay. Okay. Then I'm going to grant Mr. Harris, this is your one shot, okay? You're gonna get out on a straight PR bond, which means that you are going to be responsible to be reporting to PR bond on this particular case. If you are ever not in compliance with the conditions that I'm going to impose, then you are subject to rearrest. And I think ultimately the county can sue you for the amount that the bond is. So we're gonna leave it at 55,000, but it is gonna be a straight PR bond. You will be reporting weekly by phone to the PR bond office. You are going to have a curfew from 10 p.m. to 6 a.m. unless you are working or going to school. You're to use no illegal drug or alcohol, and you will be subject to testing. You will may not leave El Paso County. It doesn't sound like he needs to leave El Paso County for work purposes, so you may not leave El Paso County or change your place of residence without permission from the court. You're to commit no new offenses, and maintain all current contact information with the Pure Bond office. Let me see. There's no co-defendants or anything like that in this one, right? No? Okay. I think that's it. So that'll be the order. He already posted on the other one. You will be required. Go ahead, Marissa.
I'm showing that there is a co-defendant, 2021-3227, Arleth Ramirez.
Okay. Do we know a relation between the co-defendant and Mr. Harris? Because I'm going to order no contact with the co-defendant. Okay? No contact whatsoever. No telephone, no texting, no Facebook, none of that. No in-person contact. All right. Thank you, Marissa. Okay, go ahead and send the bond order over. Thank you. Thank you, Mr. Carmona. If you don't have anything else, you are.
Thank you, Judge.
Mhm.
I appreciate you. Thank you, Your Honor.
Sure.
Bye-bye.
Take care. All right. So who did I say? I think Mr. Valles is next. So Mr. Lerma, if we could have Mr. Valles next. And then I think I saw John Joseph. And then we'll handle Mr. Underwood. Okay. If I can remember that. Let's go.
On the USB?
Yeah.
Oh, okay. For the discovery? What about?
Right. Calling cause number 2019-0D04292, State of Texas versus Daniel Valles. May I have announcements, please?
Roa King for the state of Texas.
Eduardo N. Lerma on behalf of Mr. Valles, Your Honor, and Veronica Teresa Lerma.
Good afternoon. Mr. Valles is appearing from the jail annex. I basically set this case for weekly statuses considering our upcoming trial. And so, Mr. Lerma, I know you were able to show up last week as we transitioned on that motion to substitute, but what updates do we have for the court today?
Sorry, Judge, give me one second.
That's hilarious. I can hear you're muted, but I can hear you on your.
Okay, I think it might be easier that way. Judge, with respect to the discovery, we have requested that discovery be provided in a CD form or USB form. The purposes of this is because we have an investigator who we need to get going. And the problem is that neither Mr. Lerma or I can provide her our DA portal login to log into this information. It's just there's just too much information. So we're asking for a CD so that we can burn it. It's also much, much easier to follow if our file matches the state's file, which in DA portal, it's oftentimes a little bit different.
Okay, so let's stop on that one. Ms. King, how quickly can you turn over something on a, I guess, CD or USB or multiple?
Your Honor, so what we do is we only do that in instances that if the file is too big to actually upload to DA portal. And I did speak to Mr. Lerma and I did inform him about this when he initially emailed me asking for this request. We don't burn anything to a CD. That's actually the reason for having a DA portal. Only specific instances, like I stated, if it's something too big for us to upload or if something is of privacy, that's the only instances, because every time something gets updated on DA portal, then I would have to keep this secretarial duty to update and keep up with the firm. And that's why there is a login for DA portal, and that is provided to defense for that reason, so they can access it, because what they are viewing, what they have to go through, the intensive amount of evidence is the same amount that I have to go through in DA portal.
So what is the issue, Mr. Lerma or Miss Lerma? I mean, is your investigator not able to access? I mean, can't they sit down with Portal just as you as attorneys would, or?
Sorry, Judge.
You're right.
Um,
There is a little feedback though now. It wasn't the other way.
Give me 1 second, Judge, and I'll move to another.
Sure.
Judge, the reason why is because it's in the interest of time. I mean, we're set for March 18th, and it's just a lot quicker. And if we're able to have a CD, I've had other murder cases where a CD is burned, the discovery is all there.
Right.
It's just easier to manage. And we're short on time, and we really do want to be ready because the court has asked us to be ready. I don't see the problem with that. It's really hard because of COVID. We don't have a lot of people in our office. Our investigator would be working from home. And I have other clients whose cases my investigator would not be privy to.
Your Honor, if I may, the defense, I mean, they filed the motion to appoint on February 7th. That gives them more than a month. I mean, and knowing how much the type of charge, the nature of the charge, and the amount of evidence that will come with this type of charge, that is, I mean, that's.
I'm not saying we're not ready, Judge. I'm just saying I would like a CD. I can provide the CD for the DA's office. It just makes it more expedient.
And Your Honor, I'm just saying that the state is not, I mean, a secretarial duty to even update and put shift the burden on me to burn a CD, contact, I mean, everything is out there on Portal. If there's something specific, I can do that, but to burn the entire file, that's what they have to go through to view the Portal is exactly what the state has to do.
So I do have some concerns about the timing. And I know, and I'm not sure if it's in cases where the information is not available on Portal, therefore the DA provides a separate media and, defense counsel picks it up. I'm not so sure it's going to be an undue burden on the state to provide that if it's going to assist defense to get the ball rolling so that they can be ready for trial. And what I would kind of make the distinction is that there would not be an ongoing requirement for the DA to provide updates. So for example, what you have now, unless you're telling me just by virtue of the size of the data that's already on Portal, like if your office can quickly do it and put it on, I don't know, 1 USB, 2 USBs, I'm not real tech savvy on how much can fit on what type of media device. But if you can do that, then I'll grant the defense's request with the understanding that the DA does not, from this point forward, have a continuing obligation to provide that to defense. So can you tell me, Ms. King, if you know like the technical specifics? I mean, do we know, is it a really difficult process? I just don't know if you can kind of educate me on that.
Your Honor, I did ask my media room. They told me that they looked at the case. It takes around a week to get everything to download and then to be saved. It's not going to be just like a 1 CD or 1 USB. So that's another thing. I mean, if it takes around a week, that's another week that they're willing to lose, I guess. I mean, because you have to download the data, you have to wait for the data to be downloaded and then burn it to the media.
Do we know, I mean, is that able to be put, even if it took that long, is it able to be like, I don't know, there's like little hard drives. I don't know what Ms. Lerma would be able to provide that would make that transfer cleaner. Here's the thing, even if we were to go about that, or if the court were to order that, it's not, how can I say, Ms. Lerma, you all would still be under an obligation to not delay working on any of the case for the DA's office to provide that. I mean, because it is, everything is on portal, right?
Yes, Your Honor. And to just let you know, there is 267 videos, 1,307 photos, and there are 2,369 audio files.
So let me ask, because I don't remember when I used to access portal. Are those downloadable from your end, Ms. Lerma, just from portal? Like, for example, can't you save the videos, things like that on your own devices, or is that not possible? I don't remember. It's not possible.
It's very difficult, Judge. I mean, that's why for most cases, I always ask if they can burn a CD, especially for audio or video, because the downloading process can sometimes take hours. I use a Mac system, and the Mac system for me does not always coordinate with the HP system that they use. And so I'm really surprised that this is so difficult for the DA's office, because in the past I have received CDs and it's very easy, especially for the videos that we just play in our system.
Okay.
Your Honor, I don't know about the last, charges, but we're talking about a murder charge. So there is an extensive amount. And like Ms. Lerma said, it does take a while for the videos to download. And that's,
But they have it in their system. They don't have to download anything. They have the system. I mean, they have the video. I mean, short of me saying, can I make a property request? And I'll go to their offices and then review the videos there. I mean, they have the originals. They don't have to download anything.
Let me ask, so are primarily, or is the bigger hurdle with the audio recordings and video recordings? Okay.
That's what takes more time, Judge.
Okay.
And Your Honor, if I may, this is Renee Flores. Regarding the videos and the audios, we have to do the same downloading as the defense does. We press on the same button and we have to wait for the video to pop up. We do not have
Hard
the
copies?
original like here that we can just slide into a player and just play it. We work off of the portal. So if we were to ask our IT department to do that, that would take some time on it if that's what they're asking, because we are doing the same thing that they are doing, working off of the same portal, downloading at the same time, where we are waiting for the same amount of time for a download to happen. That's just the system we're in.
So when you, this is kind of just a practice question. So when we're in trial or in a hearing, when you all are playing a video, you're doing it from portal, or are you doing it? I mean, how do you enter it as an exhibit? How do you?
We get those as exhibits, and then but at that point,
We burn
for
them?
example, we have to prepare them weeks ahead of time. So for this case, we would have the videos that we plan to introduce into evidence. We have them downloaded, and we have them burnt onto, we burn it from portal.
Okay, so do you have those items that you anticipate you will need to use in that format already done? So for example, do you have the CDs of the videos that you're gonna use in trial?
Not yet, ma'am. No, because we still have, we go through all the videos and then we start checking off which ones we will be introducing into trial.
Okay. Well, I don't think this is an unreasonable request on behalf of the defense. If it will assist them, what I am not going to do is, again, make it an ongoing request. Although I don't really see it, I guess you all have been emailing or communicating about this. I don't see a motion regarding the disclosure in this format. So I'm going to order that only with respect, and I know there's still a lot of them, it may not make the volume much less, that the audio and video recordings be provided in a transferable format, CD, USB, that Defense Counsel will provide. And I'll also tell the state this, I mean, I'm not trying to bog your IT department down with all kinds of unnecessary downloading. But if you all are able to identify the specific items that you will be using at trial, I'm not trying to push your hand on that, but if you want to limit it to that list, then Ms. Lerma, if you need to make a further request, then I'm going to allow them to limit the production to those items. Okay, if you all don't want to say what that is, then by all means, let's just have all the audio and all the video. I'm going to say ASAP. Okay, we're coming back every week. I understand maybe it will take a week. I really am, quite in the dark when it comes to how quickly these things can be done. But the goal being, I'm not trying to put the state, in some, position where you're having to do all this extra legwork. But the court's intention, as you all very well know, is to go on the March trial setting. And so whatever we can all do to make that happen, I will, allow and order some of this process to happen so long as we get there. So Ms. Lerma, I would encourage, as for now, that's going to be the court order. Again, we may end up seeing, and I'll know by Tuesday whether they have turned over a tailored list or a more global set of documents, but that means, or recordings, but that means, Ms. Lerma, you all need to quickly figure out the media and provide it to the DA's office so that they can do that. And if we have any other issues on that matter, we'll be back next week on that.
Your Honor, if I may, just one request. Is there by what does Mr. Lerma and Ms. Lerma have to provide to the DA the means because of the time?
If it's various USBs, if it's I think a portable hard drive would probably be better because I think those have better, bigger storage. So it might be easier to do that way. Ms. Lerma, do you think you all can provide that to the DA's office, within a day or two?
Yes, Judge, I'll get that to them tomorrow. And I do think a portable storage would probably be easier.
Yeah, I think that'll work best. Go
I
ahead.
have shared my personal cell phone with Mr. Lerma. So if he can just let me know. So the minute, we receive it, I can give it to the IT room so we can have it burned and handed so we can save time for everybody.
Look, if there are any other issues on this or any other concerns, just be ready to address them next week. We are on a short timetable. All right.
Your Honor, there are some motions that need to be said. One of them is the motion to suppress the evidence and statements that has never been heard from the record. And there's a motion to suppress illegally seized evidence, if any. And there's a motion that we're going to file also today to produce. There was apparently a third person that was present during whatever happened. We don't know as of yet. And he's absconded, and the district attorney's office doesn't know where he's at, and I don't know where he's at. We're looking for him ourselves. None of the witnesses have been contacted, so that's going to take us some time also. We're trying to work on this 24/7, and we have other briefings that we do need to get to the Court of Appeals. Of course, we came on this case at this time when we're trying to oblige the court. We're trying to meet our many duties to this wonderful court, Your Honor. And if the court could set those two motions, we sure would be appreciative. And
so
otherwise, we're setting up ourselves for a ineffective assistance of counsel claim later on.
Okay, so how Okay, so in terms of the motion to suppress, and basically any other, I guess, substantive motion. So I have some motions to suppress, and you're right, Mr. Lerma. I think maybe 2 or 3 attorneys ago, that was due to be heard. And I really think that's when COVID hit. I mean, it's that long ago. This predated the remote proceedings. And so, Sandy, do we have anything on March 3rd in the afternoon and March 4th?
March 3rd, we don't have anything in the afternoon scheduled, ma'am.
Okay. So
March 4th, sorry.
at the very least, we're going to do that date, knowing though that we will be in trial on the 24th. So we'll do the 3rd. Oh, yeah. That's going to be tight. The 3rd and the 4th. Okay. We're going to use the 3rd in the afternoon and the 4th for any and all. These are going to be in person. Okay. I'm considering them in person hearings. Just, I'm going to ask the parties indulgence because we are due to start a trial on the 24th. So we might be cutting it a little close, but even if we can't get it done Thursday afternoon, we'll be in the queue for Friday. Okay. That'll be, you mentioned, Mr. Lerma, that there is a forthcoming motion. Please file that as soon as possible, because I think the only ones that we have were some initial, the motion to suppress. I know that for sure was filed, but we have possibly some other motions. So please email the court with your exact hearing request. And if you have that new motion, please file it so that can also be included. I know this is fluid because that motion to suppress and any other motions is probably or may depend on your review of some of the videos that are going to be outstanding or audio that's going to be outstanding. So we at least have a date set.
Your Honor, so it's going to be the 3rd and the 4th afternoons, right?
No, so it's going to be the afternoon of the 3rd and then the morning of the 4th.
Okay.
We might have to also use the 11th. That's not a holiday, right? Wait, where am I? Yes, 11th, the 11th. Yeah, I was looking at February, but they all fall the same, so that's good.
Okay.
So let's just reserve it for any and all in-person hearings on those Fridays.
I don't have anything on the 10th in the afternoon, Judge. I'm going to save that also.
Yeah, that's probably a good idea.
Yes, ma'am.
I was looking at the 7th, but that might just be pushing it. Okay. What else? What else? Anything else?
Nothing from
No,
the state.
Judge.
Okie doke. Well, we'll see you in 1 week. Thank you. We're just going to kind of keep this on track. Let me know in the interim. Emails work best with everyone. All right. Thank you
Your
very
Honor.
much. Take care,
Thank
you
Ms.
all.
Patrick.
Thank you.
Y'all are
Thank
excused.
you, Miss Sandy.
You're welcome, sir. Good to see you.
All safe,
Ms.
please.
Lerma, you still have Mr. Taylor, correct?
Yes, I was going to ask about that. He said as well.
Annex, if we
Oh.
can get Frederick Taylor, please. Frederick Taylor.
I had already checked it off. I saw Miss Lerma's name and I checked it off. I didn't even see. All righty. You're right. That's that one.
Am I
Okay.
excused, Your Honor?
Yes, sir. Thank you.
Thank
Go
you.
ahead, Chewy.
Yes, Judge. Me waiting for the defendant.
Oh, that's right.
While we wait, Judge, this was a matter that they were going to consider whether there was a deferred potential rec.
Hmm.
And I don't know if Ms. King had thought about it last time we were here. That was kind of the issue. The rec is 8 TDC, I think, or 8 or 10 TDC. I'm sorry, I haven't had lunch, but I remember it was TDC.
Your Honor, it was for TDC.
Or TDC. Okay.
Yes, Judge.
So are you still at TDC? Just making sure, because I think
Yes, Your
that's
Honor.
Ms. Lerma's question. Okay. All right, go ahead.
Clause number 2021-0D02596, State of Texas versus Frederick Elvis Taylor. Announcement of council, please.
Roa King for the state of Texas.
Veronica Ledema, Your Honor, on behalf of Mr. Taylor.
And we're here for a bond hearing. Ms. Lerma, you may proceed.
Yes, Judge. This is the second bond hearing that we've had in this case, Your Honor. Mr. Taylor is indigent. He's unable to be released on the bond as currently is set. We are set for jury trial in this matter. And as I stated previously before, the rec is a TDC rec for him. Mr. Taylor has no criminal history, Your Honor. He has ties to the community. He is his parents live here in El Paso. His father is a janitor at a school. And he would live here in El Paso, Texas. My main concern, Judge, is he has no criminal history. And so the rec is pretty high. And he's unable to make bond at this point. And I would ask the court to consider releasing him on a personal recognizance bond or a combination with a reduced bond so that he may have an opportunity to be out on bond while pending this trial.
Okay, Ms. King.
Your Honor, the state is not opposing to a reduction of bond on this case. I'm going to defer to the court, and that's because there is no criminal history. The reason it's a TDC rec is because of the, I guess, the facts of the charge.
But you all, let's see, did I reduce before? I see that it's at 40,000 with a $1,000 PR component. I gotta assume that was a reduction from whatever he had at JMAC or potential witnesses. He has no resources, Ms. Lerma?
None, Judge.
All his ties are here. Go ahead, Ms. King.
I apologize. On December 7th, 2021, I believe you did reduce the cash surety to 40,000 and to have the PR component remain the same at 1,000.
Yeah, that's what I see. I mean, so I've reduced it once and yeah, I don't know that circumstances are much different. And so for that, I'm going to deny the request for a bond reduction. I think the bond is reasonable. Ms. Lerma, just in looking at Odyssey, I do see back in December, there was a motion for speedy trial. Yes. Okay, yes, so I want to address that trial date, because if we remain in the COVID protocol where we're having to pick juries, I do not have a panel for that date. So I need to know from you, in light of your motion, if you would like the trial date bumped up to the April 7th and 8th, or to May 19th and 20th, which is dates that I can tell you we have panels.
Okay, let me, will the court just indulge me for a minute to look at my schedule, Judge?
Sure.
Judge, in light of the other case that we were just discussing, I would ask the court for the May date, just for purposes of preparation.
And what I'll do is I'm not going to remove that April 29th date in the event that COVID disappears and they take away the protocol and everything's great. But I am going to add the backup of the May 19th and 20th. Okay, so we don't reserve your spot. Okay. Thank you. Thank you, Ms. Lerma. And thank you, Mr. Taylor. Who's next, Chewy?
Okay, Judge Robles. Annex, if we can get Carlos Robles, please.
Yes, sir. Good afternoon, Your Honor. Good afternoon, Ms. King.
Good afternoon.
All right, go ahead, Jay.
Yes, Judge. It's cause number 2022-0D00060, State of Texas versus Carlos Ignacio Robles. Announcement to council, please.
Roa King for the state of Texas.
Good afternoon, Your Honor. John Joseph on behalf of Mr. Robles, and you're ready to proceed.
And Mr. Robles is appearing from the jail annex. You may proceed, Mr. Joseph.
Your Honor, Mr. Robles has been in custody for 78 days on a $20,000 bond for assault, family violence, impeding breath or circulation. He's 30 years old. He's a United States citizen. He is a lifelong El Paso resident. He is a Bel Air High School graduate. And when he is currently single, and he has a 10-year-old child that resides in El Paso. When he's not in custody, he works at Cuauhtemoc Cafe, and he also does landscaping on his own. If he is released, he will reside at 6700 Alameda by himself, and that's his own personal residence. In addition to this case, Your Honor, he has a pending misdemeanor assault in CCR 1 from a fight he got into while he was at the annex last year. And then he has this, he's accused of this AFV impeding breath. I'm not trying to litigate this case at this time, Judge, but after reviewing the discovery, there's just some glaring inconsistencies in this case. There's a proposed affidavit and supplements, I guess, that the officer had worked up in the past. And it looked like the document contains facts that were missing from the presented affidavit to JMAG. Specifically, the first one being that the officer noticed that the victim was inconsistent in her statements and the rendition of the facts. And she also claimed that there was a bump on her head. And so they called EMS out. Paramedics examined her and they let PD know that she in fact didn't have a bump to her head. There's a lot of a history between these two on how they've met that for the privacy of the CW and my client, I don't want to discuss on YouTube Live. But for the foregoing reasons, Your Honor, we are requesting a full PR bond or a reduction in bond.
Okay, Ms. King.
Your Honor, the state respectfully opposes any reduction. So a little criminal history, we have September 2008 prohibiting weapon knuckle charges that was dismissed. However, in 2010, May of 2010, DWI, he was placed on probation, then he was revoked and sentenced to 50 days confinement. July 2010, we have an injury to a child, an elderly, state jail felony. I do not have a disposition for that one. January 2011, we have a DWI second, sentenced to 50 days. Confinement, August 2012, we have an aggravated assault with a deadly weapon. That was a lesser included offense of an assault causes bodily injury and sentenced to 1 year. We have April 2013, theft of service less than 500, that was dismissed. January 2015, we have an aggravated assault with a deadly weapon that was also reduced to an assault. There was a resisting that was dismissed in 2016. We have interfere with public duties, conviction, 120 days in 2016. We have 2017 August, DWI third or more, sentenced to 2 TDC. We have resisting arrest in 2019, 6 days confinement, criminal mischief in 2020, less than 30,000, 10 months confinement. We have September 2020, possession of marijuana less than 2 ounces, that was dismissed. And we have September 2020 terroristic threat against peace officer, state jail felony, and that was 10 months TDC.
All right, that's quite a history. Your request is denied, Mr. Joseph, for future safety of the community, criminal history. I think there's some prior non-compliance there as well. Thank you very much.
Okay, thank you, Your Honor. May I be excused?
You may, thank you.
Thank you.
Next, Chuy.
Okay, Judge Monarchs. Annex, if we could get Francisco Monarchs, please.
Yes, sir.
Ready? Go ahead, Chuy.
Yes, Judge. It's cause number 2016-0D02790. Cause number 2021-0D03075. State of Texas versus Francisco Monarchs. Announcement, counsel, please.
Roa King for the state of Texas.
Good afternoon, and may it please the court, Your Honor, Richard Roman on behalf of defendant Francisco Monarchs.
And Mr. Monarchs is appearing from the jail annex. You're set for a bond hearing. Mr. Roman, you may proceed. Well, first, let me ask you this. On on the 2021 case, are you the attorney of record?
Yes, ma'am.
Do we have, Sandy, I don't know why it has a blank. Let me
Check on that, Judge.
Mm-hmm. I mean, I know we've kind of, because of the probation case.
Mr. Roman, did you by chance enter under the warrant or JMAG number? Because I don't see it under the ODO number.
No, my recollection is I filed the waivers and so forth under the new cause number. When we conclude, I can go back and look and resend them to you.
Mm-hmm. Yeah, it's very strange. I had never noticed that. I mean, I know we've kind of been operating with the circumstance of the new case, and I kind of assumed you were on it, but I don't.
And I do have the waiver, Mr. Roman, but not a formal entry, sir.
Okay, I'll get
We'll
one.
get that. Yeah, if you will get that to the court. Go ahead, Mr. Roman. You may proceed on the bond.
Yeah, thank you, Your Honor. Well, I don't necessarily want to go through this is the second or third time, fourth time maybe that we've been here seeking a bond. So I don't want to, go through all of that one more time, but just to remind the court that Mr. Monarchs now has been in custody about 120 days or close to it. He's an El Paso resident. He's a warehouse clerk at a local import-export company. So far, we understand that his job is still secure, but Mr. Morales, if he were to be released on a PR bond, is going to live with his father as he was living before. And the father's indicating to me that he's kind of heard some grumblings that unless Mr. Morales can return, his job might be unfortunately in jeopardy. And, I'm visiting with the father as well. And the next action to be taken is they're going to try to sell his car in order to try to get access to some funds.
Well, is that they're going to sell Mr. Monarchs your client's car, or
no, yeah, his car. He's not driving. It's just parked there at the house. So they're going to be looking to sell it.
Mm-hmm.
But at this point, as it stands, he cannot make the cash portion of the bond, which is $75,000 bond. So, and he's taken steps while in custody towards taking some addiction counseling classes in there, and he also has been interviewed and is being screened in Judge Anchondo's court pursuant to Your Honor's recommendation the last time we were here. So we would just ask the court if it would consider a full PR bond and or at least some kind of very substantial reduction in the bond so that he can get out and get back to work and continue getting his life in order.
Let me ask, I was unsure if DWI court could screen him while he was in custody. What exactly is the status of that screening?
They've interviewed him. He submitted the applications, and as I understand it, Miss Leticia Medina, I think is her name. It's there in screening at that court, and that's all we know at this point.
Okay, Ms. King.
Your Honor, the state actually is going to defer to your judgment on this one. This is going to be a DWI number 4. And I mean, I think he does need the help. And I know that the screening in DWI CCR2 usually takes around 3 weeks. I'm not sure when they started the process, but the state will defer to your discretion.
Mr. Roman, anything else?
No, ma'am, Your Honor, just to reiterate to Your Honor, we understand the court's not liking at all the circumstances that Mr. Monarchs has put himself in, but he's been in jail now close to 4 months, and we'd like to get him back to work so he can stay on track. Losing his job and so forth, I think we'll just could send him in the wrong direction. So we just very graciously like the court to please consider a PR bond for him.
I appreciate your argument and your efforts, Mr. Roman. Let me tell you, the request to reduce it is absolutely denied. Now, because your client is here, I know we're not set for a status, but I want you to know that I did receive a probation case summary, and I don't know I had seen as much detail. I mean, obviously, we were all operating under the circumstances that he was on DWI probation and he picks up another DWI, the driving facts alleged, not very good and whatnot. However, the case summary that I received from probation shows an extensive history. I know driving, just the mere fact that he picks up a new allegation is serious enough, but at least beginning in March, and literally up until the point when he picks up the new case, was in complete violation with that monitor, meaning he wasn't testing wholeheartedly. He was tampering with the device. He was testing positive. I mean, I've got almost a full page of violations over the course of 3 months. And I understand, yes, if he has a problem, that's going to be consistent. But what it tells me is he has very little ability to conform his behaviors to any type of conditions, whether they be PR, probation. I have no confidence in your client, zero. I'll be very frank with you. When I mentioned DWI court, I did mention that because I wanted us to have options. Having reviewed this probation case summary, and believe me, I have had extensive meetings based on the supervision or lack of supervision or reporting to the court, just based because of your client. Because Mr. Monarchs is the type of person that, but for the grace of God, he didn't kill anybody in July. And he had shown us that he was not going to follow rules. He had shown us, and it had not been reported to the court. So no, I'll be very frank, it's going to have to be a compelling argument for me to even consider DWI court at this point, because I just don't think your client will be able to conform his behavior. The bond request is denied. We will see you at the next setting.
Thank you, Your Honor. May I be excused?
Yes, sir. Thank you. Who's next, Chuy?
Okay, Judge Ortega. Annex, so we can get Andrew Ortega, please.
Yes, sir.
All right, go ahead, Chuy.
Yes, Judge. It's cause number 2019-0D03894, State of Texas versus Andrew Ortega. Announcement of counsel, please.
Our king for the state of Texas.
Are we missing Mr. Where was he?
I believe it's Mr. Quinata.
Mr.
Derek
Quinata, are you there?
I sure am. Good afternoon. Good afternoon.
All right. So Mr. Quinata is here on behalf of Mr. Huerta. For Mr. Ortega, we are scheduled for a revocation hearing. Somebody give me an update. Carla, are you there, or who has an update?
Yes, Judge. I'm here. Your Honor, Mr. Ortega, we had addressed, well, I'll start off by letting you know, he's on a DWI 3rd or more probation. He was placed on 5 years, September 12, 2019, and absconder from October 2019 to October 2021. He was picked up, Your Honor. I want to give you the correct date of the rearrest. November 13, 2021. He was arrested on the warrant, Judge, the MTR warrant, and a resisting arrest charge.
Right, is this the one they went and got him in the mobile home? Is that where it was? They found him and there was some issue with the family?
Yes, I believe so.
Okay.
So the last time we were, well, we've had 2 other hearings, Your Honor, December and January, and you had, if you were to consider letting Mr. Ortega out, you had referred to Mr. Quinata to talk to the family regarding the monitor, since this is a DWI 3rd or more, and he doesn't have the monitor, and he hasn't done anything on probation.
Okay, so sorry, I had printed out your report, Carla. I apologize for that. He was also driving without the court's permission. What do we know about a monitor, Mr. Quinata? It doesn't sound like we have one.
Well, Judge, it's my understanding that his family is amenable to getting the monitor should he be let out on bond, Judge.
Well, I mean, we just kind of seem to be spinning our wheels here. We came in December a couple of times, then in January, now here we are again. My point is this: if he wants to get out, if he wants me to even consider getting out, we need to see a monitor, and I don't see that. So we're just wasting time, or he's racking up time, and we.
Okay, so with that said, Judge, can we proffer to the court via email proof that they have obtained the monitor and with an order, with a bond order?
I will give you another hearing if you show me you have a monitor. Other than that, we're just gonna go to revocation. We're set for revocation for the second time today. So Sandy, we'll do 30 days revo. Let's put that on a Thursday afternoon. So crazy. With a Thursday morning status, so we check on it just to make sure in 30 days. And feel free to send it on over. If not, be ready to go on a revo on Thursday afternoon.
Very well, Judge. And so with that said, for clarification, well, there's no specific monitor, just
Oh, no, there is, has to be a portable monitoring unit with daily reporting and GPS.
Indeed, Your Honor. Very well. We'll go ahead and attend to that ASAP. It was our understanding before it was hard times, but now they are ready. So.
All right. Well,
thank you, Judge.
Thank you.
May I excuse, Your Honor? Thank you.
Yes, sir. I know we have at least one plea based on the faces I see here, or not the faces, the names. Is it Mr. Martinez, Jesse Martinez? Thank you, sir. Thank you, Mr. Ortega.
Yes, Judge. Annex, if we can get Jesse Martinez, please.
Yes, sir.
Ms. King, are you handling this one?
Yes, Your Honor, I am.
Okay.
Hello, everybody.
Hi, Mr. Underwood. All right, Mr. Martinez. Can you hear me okay? I couldn't quite hear you.
Yeah, I can hear you.
Perfect. Okay. Let's go ahead and get started. Go ahead, Chuy.
Yes, Judge. It's cause number 2016-0D0-3012. State of Texas versus Jesse Adrian Martinez. Announcement of counsel, please.
Roa King for the state of Texas.
Justin Underwood on behalf of Mr. Martinez. We are present and ready, Your Honor.
And Mr. Martinez is appearing from the jail annex. We are scheduled for a plea today. Mr. Martinez, I'm going to be asking you some questions regarding your plea. If you would, please raise your right hand. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you state your name for the record, please?
Jesse Adrian Martinez.
Mr. Martinez, I'm going to be asking you questions about documents you may have reviewed with your attorney. The first of which is marked as State's Exhibit number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Martinez, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, Judge.
And did you understand everything contained within the document?
Yes, ma'am.
Mr. Underwood, have you had more than 10 days to prepare a defense in this case?
Yes, ma'am, we certainly have.
And did you explain the plea papers to your client?
I did, yes, ma'am.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Based on our conversations and his questions and his responses to my information, absolutely, Your Honor.
Okay. Let me see, Mr. Martinez. It's been a long afternoon. Are you satisfied with your attorney's representation of you?
Yes, ma'am. Satisfied.
Perfect. Mr. Underwood, do you have any reason to believe your client is not competent to enter his plea today?
No, Mr. Martinez is very competent.
Mr. Martinez, have you ever been found incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who's found you mentally ill?
No.
Okay. Based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea today. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
El Paso.
El Paso, Texas?
Yes, ma'am. Paso, Texas.
All right. So I understand on the indictment, you are pleading only to count 1. Count 1 is a charge of murder. To that charge, sir, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, ma'am.
I will find you are making your plea freely and voluntarily. Ms. King, would you summarize the evidence, please?
Yes, Your Honor. Were the state to proceed to trial on the indictment, the state would have proven each and every element, the offense charged to be under reasonable doubt. Judge, the defendant is going to plead to 15 years confinement in the Texas Department of Criminal Justice Correctional Institution Division. And at this time, the state moves to admit Exhibit 1 is the state's plea paperwork, Exhibit 2, Article 3914 disclosures, and Exhibit 3 is the indictment.
All without objection, Your Honor.
States 1, 2, and 3 are admitted. And Mr. Underwood, is that your understanding of the plea agreement?
Yes, ma'am, it is. He's entitled to all the credit that he's been. This case was pled originally and was overturned on an appeal, and so we reopened it. But I believe he has almost 5 calendar years of credit. So yes, ma'am, that is our understanding of the plea agreement.
Great. And Mr. Martinez, is that your understanding as well?
Yes, ma'am.
Okay, understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea, bargained, or negotiated case, you do not have an automatic right of appeal. Mr. Martinez, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
It's signed by your attorney and signed by me as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty in count 1 of the offense of murder. I will sentence you according to the plea agreement, 15 years confinement in the Texas Department of Criminal Justice Institutional Division. You will indeed get credit for any and all time that you have served. Is there anything further, Mr. Underwood or Ms. King?
Nothing further from the state, Your Honor.
No, ma'am, Judge. Thank you very much.
Thank you for your time and all the effort. I do remember when this came back down, you and Mr. Briggs assured
Yes,
that
ma'am.
you all would take care of it and you handled it very well. So thank you. Good luck to you, Mr. Martinez. Thank you.
Your
Ms.
Honor,
Monday.
Your Honor, I do have a question. I only can, the report that I run only reflects the time that he spent in El Paso County Detention Facility. I would need someone to provide me the dates that he was at TDC, because the warrants, like when we bench warranted it over, isn't necessarily gonna.
What I think you can do is I think you can look at the old cause number, I would imagine, would have the judgment and sentence on it. And I would imagine the state of Texas would probably have the PIN packet generated already as well.
There's a different cause number, Mr. Underwood. I'm sorry.
I'm sorry, no, because it was not refiled. I apologize, Judge. It was not
The easiest thing would be was your client ever out of custody after being arrested?
No, ma'am.
Okay, then I can just go to the original date of arrest, Your Honor, to calculate the time credit.
That'll be the order. Yep.
Awesome.
Perfect. Thank you, Marissa.
Thank you,
All right.
Marissa.
All right. Good luck to you, Mr.
And
Martinez.
excuse Your Honor.
Yes, sir. Thank you very much.
Jesse, we'll talk soon.
All right. That's it.
All right. Who's left? Is anyone left?